There we go. Okay, welcome back to Senate Education. Uh, Jim, I wondering if you would please bring us back to the topic when we were talking with Professor Teachout and yourself around some of the issues we're dealing with around church and state. I know you have put together some options for us to consider around what we might do to protect that line, if you will. And so I'm wondering if you could just give us an overview of your thinking and why this direction you think might make the most sense, and then a little walkthrough of the bill. And we're not going to be making any big decisions today, but it will just help focus us, I think.
Sure. Yep.
Thank you.
So, for the record, Jim Damerman, that's Counsel. I think this area, because it involves a constitutional principle, which has been interpreted many times by the courts, is frankly quite confusing to understand. So before we go through options and language, let me just help define, if I could, the problem you're trying to solve here. And the problem you're trying to solve here is that the Vermont Constitution has this clause called the Compelled Support Clause, which essentially says that citizens of Vermont cannot be compelled to support any religion. So, so the way that's been interpreted by the Vermont Supreme Court in a case back in the 1990s called Chittenden Town, the court said, yes, you can provide tuition, public tuition, to religious schools, but you have to be sure, you have to take some safeguards to ensure that those funds are not being used for religious instruction. Okay, so so you have that guidance from the Vermont Supreme Court over 20 years ago. And the problem that we have is that districts have been denying use of public tuition for religious schools like Rice High School. They've been denying it because they are religious schools. So they haven't been applying a safeguard against a use. They've been saying, as a blanket statement, we can't fund you because you're a religious school. So the Supreme Court has held you cannot discriminate against a religious school solely based on its status. So the recent cases that have been coming up in Vermont, we've seen there have been some holdings that basically have held that Vermont is discriminating against these schools based on their status, because that's what the record has shown in the court record. It shows denial by districts on that basis. And what hasn't happened in the 20 or so years since Chittenden Town was decided, there's been no state directive going to school districts as to how they can establish safeguards against improper use. The districts have been on their own to figure that out, or just to deny funding based upon status, which is unconstitutional. So that's the problem. The problem we have is we're in a situation now, we've got court cases that are in live flow here, which are coming against the state because we really haven't defined what those safeguards look like. So what the AOE did in February of this year is they issued for the first time non-binding guidance to school districts as to what those safeguards might look like. The AOE says in its guidance that that it has no authority to bind school districts, because it's really a district issue, not an AOE issue. So it's given some guidance, and then Professor Teachout came in and testified as to a process for certification. You heard from him, which is part of the guidance that the AOE gave as well. But I think what an option for you is to give direction to school districts saying that you shall provide funding to these religious schools if they provide the district with a certification. The funding is not being used for the purposes of religious instruction, worship, or propagation. So what I have here for you today is a bill that gives that direction to school districts. And with that direction, the state is now saying to school districts on a uniform basis, here's how you do it. And therefore, it will allow school districts to fund religious schools if they get the certification and they're not using those funds for improper purposes. Let me pause there before I go on. Is there any questions? Any questions about that framing?
Any questions? So are we putting here, Jim, in effect, creating a certification program?
Yeah.
Senator Terrence, do you have a question? I saw you just up back. Okay.
So let me share my screen for a minute. I'll come back to, we talked as well about the idea of conditioning funding on application of anti-discrimination laws, right, to these schools. I haven't put that in the bill, and I'll explain why. But let me go through the bill first, and then we can talk about that element of it as well.
Thank you.
I'm going to share my screen if I can. Yeah, screen too good. And share that. I'm going to bring that over. Like this. Okay. Can people see this?
Not yet. There's
No?
just the old Windows. Is that the old Windows? I don't even.
It
Let
looks
me
like,
try again. Hold
looks like it wasn't opened up,
Share
I think,
screen.
yeah.
on.
You need to
Okay,
open the
again.
document on your desktop screen.
I did that. Yeah. Yeah. Let me find it again.
You take your time while you're doing that. I don't know if anybody has seen the perhaps the worst or the funniest technology mistake that I've seen in a while with the attorney who had the cat filter on. Has anyone seen that?
Oh, yeah.
I mean, there is nothing that tops that one. I will send it along. I will send it along.
I sent it to Dick Sears.
Oh, you did?
My daughter sent it to me like at 6 o'clock in the morning, and then I said, oh my God.
Yeah.
Well, I saw in the news, I think it was no less than a week ago, and I don't know if it was a Senate or House committee in New Hampshire, but there was a legislator whose cat continued to get in the screen, and that caused some frustration for committee members to the point that they're trying to do something to ensure your pets are not seen in the New Hampshire legislature.
Really? Because
Yeah.
you know, my cats, one of my cats will sometimes jump behind me, and Senator Pearson in finance, you know, his cat when I was on finance would always pop in, and other cats. Yeah, that's funny. Where people, I wonder why they want to stop seeing pets in the screen. Maybe just because of that.
I didn't dive into it. My kids walk in front of the screen 4 times, 6 times a day. So I mean,
Right. Yeah.
how can you be upset? But
Last year in this committee, we saw a lot of pictures of Senator Ingalls' cats. She just would show them to us around the committee room.
Oh, Senator Ingram's.
Ingram, yeah, not Ingalls. Ingram.
Yeah. Jim.
Yeah, I'm having trouble here. I'm not sure why. I'm sorry.
You take your time. If it's better for you, we can always follow along.
Is it on the committee?
I believe it's been posted.
Yeah, if you don't mind, that would be
No, that's
this
fine.
time.
Yeah.
This time, that's probably better way of doing it. Okay.
Does everybody have it? Can everybody find it? I have a,
No, which one is it on there?
let's see.
Senator Campion, if you give me a couple of minutes, if you want me to post it, I can.
I don't see it there.
If you have not posted it, yeah, that would be great.
I have posted it, but
Oh,
do
you-
you want me to try to share it?
Where,
Where is it on the committee page, Jeannie?
It's under Jim's name, second.
It should be
posting.
under Jim's name.
Okay,
I think it's the second one. The first one was the bill
yeah,
that we just finished, and then,
okay,
got it.
oh, great. And great, everybody have it? Okay, great.
Okay.
Thank you.
Okay, good. So I will go through this draft. It is a draft that could be Canadian bill. Right now, it's under Senator Campion's name. And it proposes to prohibit school districts from paying tuition to certain schools or programs, regardless of religious status or affiliation, unless it receives certification from that school or program that none of the tuition for which payment is requested has been or will be used to support religious instruction or worship or the propagation of religious views. So there's findings and purposes. Let me take you through those because it emphasizes again what I said at the beginning. So first you have the Vermont Constitution has the Common Support Clause, which provides that no person can be compelled to support any place of worship contrary to the dictates of conscience. And then in Chittenden Town, decided back in 1999, the Vermont Supreme Court held that a school district violates the compelled support clause when it pays public tuition to a religious school in the absence of adequate safeguards against the use of such funds for religious worship or instruction or the propagation of religious views. And it says the purpose of this act is to define adequate safeguards that a school district must employ to ensure that public tuition is not used for religious worship or instruction or the propagation of religious views. So section 2 amends a section of statute dealing with the payment of tuition to schools. So A is not amended, but what A says is that a school district shall not pay the tuition of a student except to a public school and approved independent school, and independent school meaning education quality standards, a tutorial program approved by the state board, an approved education program, or an independent school in another state or country approved under the laws of that state or country. So you can pay tuition to that list, okay? And what B says is that a school district shall not pay tuition under subsection A of this section to any of the schools or programs identified in that subsection, regardless of religious status or affiliation, unless it receives certification from that school or program that none of the tuition for which payment is requested has or will be used to support religious instruction or worship or the propagation of religious views, provided that public schools that receive tuition from a school district are exempt. So we're not requiring public schools to certify this because they are public schools. For any independent school, tutorial program, etc., listed in A, this certification would be required. And then it goes on to say, instruction in religion that focuses on the history and teachings of various religions shall not be deemed to support religious instruction or worship or the propagation of religious views, provided that the instruction is not designed to and does not support religious instruction or worship or the propagation of any one religion or theology or group of related religions or theologies. That is designed not to prohibit schools from offering survey courses in religion.
Right.
That language might need to be tweaked a bit, but that's the idea behind that language.
I mean, that
And I
could
want to
even,
go over to,
Jim, that could even be, a school offers, Thetford Academy offers a course in the New Testament. They can still do that. I mean, or does it have to be survey or?
well, I'm not sure. So that's where we need testimony, I think, on that. You need testimony on that because I wrote it to be kind of survey-like, more or less.
Okay.
I'm not sure how to write that. If it's a course in a specific religion, it gets to the point where it seems like religious instruction. So I'm not sure how you draw that line.
Okay.
So I wanted just to mention Professor Teachout's testimony. He recommended this same certification in his testimony. And he also mentioned that the certification approach is simple and practical. And he says the great advantage of certification mechanism is that it avoids the need to get into any great detail about which expenditures might be eligible for tuition reimbursement and which might not be. And then he goes on to say that the mechanism of certification is a familiar mechanism used by both the federal and state governments with court approval. So this method we're talking about is been approved by the Supreme Court and by various courts. So it's a tried and true method of providing a safeguard. So I'll pause there before we talk about discrimination. Let me pause there in case you've got questions on the bill language itself or the approach.
Any questions? Senator Terenzini.
Thank you, Senator Kami. Senator Hooker understands I'm thinking of locally, we have a Catholic elementary school and we have a Catholic high school. And, if you decide to send your children there, you pay the tuition. It's not funded by, tax dollars. So we already have that in place. I guess maybe I missed a part, but what are we just trying to strengthen that foundation, or what are we trying to accomplish with this bill, Senator Campion?
Sure.
Because I already thought it sort of is already in place that we're not paying for kids to go to these Catholic or private religion schools.
So this probably wouldn't impact, I don't think, your schools at all unless you're not in a choice district. So correct me if I'm wrong, Jim. This is we're saying if somebody, these are schools that if you're in a choice district, you would now be able to, right now you're able to take your choice dollars to a religious institution. And we are getting sort of mixed things happening out there. Some people are saying yes, some districts are saying no. This would give some clarifying language to make sure that schools know under what circumstances districts know under what circumstances they could be sending and to what schools. Does that make sense, Jim?
Well, let me reframe that answer a little bit if I could. Certain schools in Rutland, there are tuition districts nearby, right? And they could send their kids to private schools in Rutland. Also, if you're a public operating school, you can send, if the district allows it, you can send your child to a different school outside the district, pay for with tuition dollars, public tuition dollars. So, for example, a school that operates schools, a district that operates schools, maybe it doesn't have a program that a child wants, but maybe it's over there in an independent school. So both for operating schools in more narrow circumstances and for tuition districts, they can send students to independent schools. Under current law, they, as you mentioned, in Rutland, the religious schools are, parents are paying their own, out of their own pockets for those programs.
Right.
Because school districts have been saying we can't provide funds to religious schools. But that's not what the Vermont Supreme Court said. Vermont Supreme Court said that you can provide tuition to religious schools if there is a safeguard that those schools aren't using that funding for religious instruction. So imagine that the school in Rutland, the Catholic school in Rutland, has a system that says, okay, we're going to take public tuition, but we're going to use it to pay our physics teacher or our gym teacher or whatever. We're not going to use that to pay for religious instruction. We're going to use that in these other areas that are not for that purpose. That is permitted under the Vermont Constitution and under the Chittenden case. But what's happening today is districts are saying no. Because you're religious school, you can't do that, and that is unconstitutional. So this is a way to thread that and basically give guidance to school districts to not say no, but to say yes if you have safeguards in place. And the way to do that is through a certification. So with this change, Rutland, or let's say Chittenden is a tuition town. Chittenden could pay tuition to your Catholic school in Rutland if the Catholic school in Rutland gives a certification to Chittenden School District that the funds are not being used for religious instruction, worship, or propagation. So it would change what's happening on the ground now.
Okay, so that helps a lot. So let me just pitch a scenario. I live in Rutland town, so we don't have a high school. So I had school choice. I could have went to Rutland or Proctor, West Rutland, or wherever. I could have gone to Mount St. Joseph's in Rutland if I wanted to. And right now, per Vermont Constitution, Vermont law would have authorized the tuition to be paid to MSJ on my behalf.
If they could certify that it's not being used for religious use, yes.
Interesting.
That's been issued since 1999. But as I say, there's been no guidance issued since that date. So school districts have been on their own.
I think this is maybe Senator Hooker knows more, but I think this is a sort of a hidden secret to most people. I mean, I've never heard of this before. You just live around here with Catholic schools. You know, if you're going to the Catholic school, you know your parents are paying for it, or you're going to the public school. So this is interesting to me.
But wasn't that one of the cases that was brought up in Chittenden? I mean, I know that there was discussion about whether or not the kids from Barstow could go to MSJ.
Yeah, so the case that came up was Chittenden back in 1999, which was exactly Chittenden involved actually going to, I think, Mount St. Joseph. So
Yes.
that was the case actually. And there have been a number of cases since. And a year ago or so, the Supreme Court in the Espinoza case said that you cannot discriminate against religious schools based upon their status. And that's what's been happening in Vermont. So the kind of urgency around this, if you will, is that we are not well placed right now to get on the right side of the line. And giving some guidance to districts as to how to do this in a way that is constitutional is the purpose for this bill would serve.
Does that help, full Senator Terenzini? Yeah, okay. Jim, given that the Espinoza case, that was a federal case.
Yes, Supreme Court.
Are basically all the states right now in the union dealing with this same kind of thing? I mean,
Well,
maybe not grappling with it or trying to do what we're doing, but if you're in Wyoming, has this opened up, that Espinoza case has opened up a similar opportunity situation where they too can say, if their version of Rutland Town in Wyoming can now send their kids to their version of the Catholic school in Rutland?
yeah, so what's happened, interesting, I think the Espinoza case dealt with Montana law, actually. And I think I mentioned in my slideshow a while ago, many states adopted the so-called mini Blaine amendments in the 1800s, which were amendments to the Constitution called no aid provisions. Those provisions said the state shall provide no aid to religious organizations. Okay, and the Supreme Court found that's discrimination based upon status. That's what it said. So it struck down essentially the Montana Constitution provision. And likewise, states that have that provision was adopted as an anti-Catholic thing back in the 1800s. And so many states have that provision. We don't. We've got our compelled use provision, which is around how you use funding. So we're in a much better place in terms of constitutional law in Vermont. We are consistent with the U.S. Supreme Court. But in practice, we're not. Because in practice, school districts have been denying public funding to these schools based on their stats. So while we're okay constitutionally, right now, we're not okay on the ground. And that's what this is designed to cure.
Okay. Senator Hooker.
Thank you. Jim, with regard to the certification, I know that, you know, we're as long as they can certify that they're not going to use it for religion-based studies or payment to staff and all of that. What else would that include? I mean, how do they have to itemize, you know, each of the things that they're not going to use it for? And what do we have any sense or parameters around what are those functions, those religious functions? I mean, talking about the possibility of offering, say, a survey of a comparative religion, that would be okay, but hiring someone to teach theology would not. Is that correct?
Yeah, it does leave the language in the draft bill now leaves it quite open and vague, for sure. And that was a recommendation of Professor Teachout, because he was worried about going down the other avenue, trying to define all these parameters in terms of segregation of funds and things like that. So his idea was keep it simple, make it a certification, which has been accepted by the courts. But it does open the question as to, you know, is there some audit that's done after the fact to find out how they use the funds? Is there some control? I mean, you're basically relying on the honesty of the school to certify. So you might decide to, you know, pad that out a bit and have some audit work done or have some parameters. But his recommendation was keep it simple and just do this. But it's up to you, of course, what you do.
But that then begs the question of, you know, blended funds and separate accounts from tuition coming from public schools.
Yep.
Okay.
It is very much, it sounds like the honest, you know, the honor policy here, you know, please do this. And we hope that, you know, you'll abide by what we're saying. I still worry a little, you know, well, we'll get into the anti-discrimination stuff. Senator Perschlick and then Senator Lyons.
That was going to be my question about the anti-discrimination stuff, if we were going to get into that or not.
Yeah, I think that's going to be next after we finish up with other questions. Senator Lyons.
That's also my question, but yeah, a comment that, gee, I really hope we can trust religious schools.
Yeah.
Seriously.
Yeah, no,
The moral fiber.
Right. So before
Maybe.
we do go to anti-discrimination, is there a way to, so let's talk about the teaching of science, for example. Should we say that science has to be followed by the Vermont standards? If, you know, creationism versus the teaching of, evolution? I mean, are there things there that are concerning to you, Jim?
Well, I guess where I'm thinking about this from, I'm trying to not go into policy and into your jobs. I'm trying to tread a line here, if you will. What I see is the courts are facing bad records. They only decide what's in the record. Right now, the records are showing decisions by school districts that are based upon not providing funds based on status. So the goal here might be short-term goal, do something quickly to get the record in a better place. So of course have a record that you've taken action, and give them guidance. It's mandatory, and at least they have a record so they know that we're not discriminating on that basis. Whether you go further and add anti-discrimination language or various other conditions, if you do that, my fear, frankly, is that you're going to bog this bill down so much that it might not make it through, and we're going to have the same record we have today the courts are looking at. So you can always take on the discrimination point at a future time in terms of what schools have to comply with. But so I was separating that conversation in my mind a little bit because I was just concerned that addition could really affect the likelihood of this fix being put in place in a short-term way to create a better record for the courts for Vermont.
Are you particularly concerned with, us getting something through the Senate, the House, and the governor's signature if it has the anti-discrimination? Because I feel that I wouldn't personally, I feel pretty confident that we would be okay there.
Well, I guess my concern is more around constitutional issues. So I think once you start adding those things in, you raise a host of other issues that have to be dealt with. So, for example, we talked before about applying labor laws to religious schools and the exception they have for people who are considered to be kind of ministerial function. So in the U.S. Constitution, as interpreted by the Supreme Court, there is an exception where those schools can discriminate against an individual who's an employee, and they can discriminate on the basis of age, of sexual preference. That's protected by the Constitution. So if you try to add that as a condition here, you're up against the constitutional issue there. And I don't know, as we talked about before, we've got the anti-discrimination laws in Vermont based on public accommodation. And I'm not clear in my mind whether those laws apply to private schools or don't, because it's not clear to me that they're open to the general public because they're private schools. So I think if you add that provision, maybe it's okay, but I think you have to hear from the right advocates around those laws to figure out how they apply or don't apply, what the issues are. So I think it gets a lot more complicated once you go down that path, because it raises other issues. I'm not saying it's not a good idea from a policy standpoint. I'm just saying it raises more issues.
That's helpful. I wonder, and then Senator Hooker, if we've heard from Professor Teachout, which was helpful. I'm not questioning his skills or talents, but wonder if we should also hear from another constitutional expert, and that's just something that maybe we can talk about in terms of possibly finding one or just getting another opinion. Senator Hooker.
I don't know if this has to do with anti-discrimination or what, but would this be open to every religious school? Or are there some kind of parameters around? Well, I guess it would be discrimination if we didn't open it to everyone. But you have some people who open a school with certain religious intent, And, it may just be in somebody's house and kids are going to that school and, they would have to be recognized, correct? Under,
More than recognized. So schools which are eligible for public tuition, whether you're sectarian or secular or wherever, have to be approved by the AOE.
so they
To
have
be
to
approved
be.
by the AOE, they've got a bunch of standards for approval based upon academics and teaching, and so you have to be approved first. And some of the religious schools are approved, like Rice Memorial is approved, even though it doesn't take public tuition because it wants the staff to be approved. But in order to take public tuition, you have to be approved. So it can't be anybody, it has to be an approved independent school.
Okay, and that, of course, has to comply with all kinds of regulations to be approved. Because we
Correct.
do have another religious school in Rutland that is, has been running for quite some time. I'm not sure what their status is.
Senator Perschlick. Anything? Or your
No,
question?
I'm still interested in the state's interest in ensuring that these schools that are getting public funds aren't discriminating. And maybe that's through that, a public accommodation, portal, if you want to call it that. So I guess I'm just saying I'm interested in that conversation to hear more about that. And is there anything the state can do about that?
Yeah, no, I too am interested. Senator Lyons?
Yeah, but I do think that once you consider anti-discrimination for the institution, then there is, let me just ask this question, there is no requirement that the institution accept or allow for any certification to receive the public dollars. So they wouldn't have to do that. I mean, they wouldn't have to, right? I'm asking Jim that question.
So under this bill, any school, any independent school, any approved independent school, whether secular or sectarian, would have to certify that they're not using the funds for.
Right, but they don't have to accept any funds. There's
No,
no
they don't
reason.
have
Yeah,
to.
so then if there is an anti-discrimination policy embedded in our bill, then independent schools say, well, look, what we want to continue doing what we're doing, period. End of conversation. Then the question is who suffers from that? Then the kids don't have the opportunities. But it also then it also says that they're discriminating against kids. So it's that circular argument. It's just pretty horrific.
Well, it sounds like it would be if the school said, if we said you needed to follow the state's anti-discrimination policy and the religious school said, no, we won't accept out LGBTQ teachers. We, will have students, we kind of have that policy, then they would just have to find another school to go to, basically, if that's, their choice district might, if we, let's just take, you go to Proctor or Burton Academy instead of the religious school.
So the question is, do we want to look at anti-discrimination?
Do you think, Jim, it makes sense, and committee members, but Jim, you might know more on this. Does it make sense for us to talk? Who else does it make sense for us to have this conversation with while we're making a decision? For example, does it make sense for us to have the Attorney General? And does it make sense for us, to hear from other individuals in particular?
Well, I think the Human Rights Commission, right? They're the ones who administer the accommodations law. So definitely from them. labor, the expert in the office on labor issues is Damien Leonard. So if you want to hear more about that exception that we talked about in labor law, he'd be helpful. AG, I'm not sure. AG's been involved in
Yeah.
some of these cases, so you might want to get their perspective. I'm not sure.
Chris Curtis from that office might be somebody who might be helpful there. Senator Lyons, were you gonna?
Oh, no, I was thinking, Bryn Hare's been really helpful to me in looking at constitutional issues, and I'm
Great.
wondering if what your thoughts are with another ledge council on constitutional issues. I mean, as compared with Peter Teachout, it's kind of difficult. That's a question for you, Jim.
I'm not sure that Bryn covers this area specifically.
Okay.
The lawyer that covers the accommodation laws is David Hall.
Oh, okay.
Yeah.
Whew.
So, I'm sorry, did I interrupt, Senator Lyons? Were you going to have to say something else? Okay. So I will, if it looks like perhaps the committee is interested in hearing then more information on whether or not we should include anti-discrimination language if we were, going forward. So we will go ahead and we will I will reach out and work with Jeannie, who and continue some testimony. In terms of this, the urgency of this, Jim, this is something that you think, in your professional opinion, we need to do something with this session, this year.
Well, I can't say it that way because
Okay.
it's on my role to tell you that. I am just seeing that the record before these courts,
Yeah.
they're looking at these cases, it's not very good. Because the record is now based upon status.
Yeah.
And districts haven't had the guidance they need. So if you want to have a better record going forward, for the courts to consider, this is a step to take. This is a option to take in that regard.
Yeah.
Yeah.
And it sounds like also I will talk with Senator Sears a little bit also this weekend to see if maybe as we're working on this, they might want to have their eyes on it either early, or if they'd rather wait until we vote something out and then kick it down their way for them to have a look before it makes its way to the floor, which I would feel good about. Jim, anything else from you? This very helpful. We had jumped into this a little bit, challenging topic. And I will work with Jeannie to bring some additional perspectives in next week. Senators, anything else on this? Or anything else for the week before we say goodbye to one another for a few days? Senator Perschlick.
We could use the term science-based religious instruction.
We could.
Oh. Do I hear evolution?
Just tie it in with the literacy, science-based, everything will be science-based.
Everything.
Yeah.
Evidence-based religion. Evidence-based would really be the coolest, right?
Wait a minute. They're all based on faith.
Exactly.
Right. All right. Nothing else on this, nothing else on any other topics. Please, I'm going to jump in soon after this and try to finish up what I'm going to talk to Senator Kitchell about, and we'll send it all off to you for your okays or your edits. And feel free, as usual, please edit freely. And if you want to call and talk about it, that's great too. So, okay. Thanks, everybody. I really
Oh, thank
appreciate it.
you.
Thank you. Jim, thank you.
Thank you.
send your vaccine questions in, please.
Will do. Happy
Yeah.
Valentine's Day, everybody.
Oh, happy Valentine's Day. Take
Valentine's
care.
Day.